amendment presently. So members, we move now to consideration of the Family Court Proceedings Reform Bill, and the question is that Part 1 stand part. Andrew Little.
Thank you, Mr. Chairman. It's a pleasure to take a call on this very important piece of legislation that has its origins in the long-standing concerns over the operation of the family court and the family court jurisdiction. And so I think it's timely to point out that this bill had its genesis in, I think, very well-intentioned and very noble action on the part of the government. It started off with the government hearing the concern about the need for the family court to modernise and especially to reduce delay and anxiety about the way it was resolving or dealing with some family disputes. And an environment that was changing too for families, where the demand, particularly from men, to play a greater role in their children after separation, that was causing putting more pressure on the court in terms of time and claims for legal aid. And so the government of the previous Minister of Justice did the sensible thing of calling together all parties who had a stake in this matter for a consultation session here at Parliament, as it turned out, and took time to hear people and hear what the concerns were and hear about suggestions for reform. And then following that minister then set up a couple of processes. They got around the legal profession, but also set up an external working group to assist that minister to come up with some solutions. There was a process of putting together a paper that then drew on public submissions, and all of that was then meant to lead to a set of reforms that reflected the actual concerns that people felt. Sadly, by that time, a different minister took over. In fact, it turns out it was the minister who's now in the chair who took over the management of the procedure, of the reform process. And what emerged was, and I really now take my lead at this point from the external reference group itself, what emerged was a bill that bore little relation to what came out of the consultation that had led up to that very point. And what we ended up with, and what we have ended up with, Mr. Chairman, is a bill that is much less about the effective and efficacious disposal of family disputes and more about saving money by reducing legal aid and reducing court time. I think it's timely, as we think about these changes, just to reflect back. And there was an article in the New Zealand Lawyer online, the 20th of May 2011, that was a retrospective about the family court. And it's interesting, gave an account of the original intentions and origins of the family court. And what the author of that 2011 article said was this: the Royal Commission that had been set up to deal with to look at the court system, and in particular to make recommendations about the family court, what they said was this, quote, "The Royal Commission noted that the aim of the court, that is to say the family court, should be to help resolve problems with the cooperation of the parties, wherever that is possible, with the minimum of disruption in all cases." End quote. And the author goes on to say, quote, "This focus on conciliation put the spotlight on providing services which assisted families to cooperatively resolve disputes. The Royal Commission recognised that self-determination rather than judicial determination often required expert assistance. That expertise was counselling and mediation." End quote. Now, you could take those words, which was a summary of the Royal Commission's report 33 years ago, and they resonate very closely with the very words that sit behind, or at least provided in the summary of this bill. It is all about an emphasis on resolving disputes between the parties. The difference is, 33 years ago, they recognised that actually couples who separate sometimes need professional assistance to arrive at that point. And they need assistance to understand their legal rights, and they need assistance to get through the emotional and difficult time that it is for the couple and any children that might be involved as well. The Royal Commission of Inquiry into the courts described the family court as having a twofold function, judicial and therapeutic. And it described its therapeutic jurisdiction as defined by the fact that there were clinical services that were required, social workers, psychologists and psychiatrists. And so, Mr Chairman, it's against that background that we consider this bill, Mr Chairman,
Andrew Little.
We just consider this bill on this occasion. And, Mr Chairman, just going through some of the relevant parts of Part 1, which deals with the amendments to the Care of Children Act, which is a very crucial part of much of the work of the Family Court. In fact, 40% of the applications that go to the Family Court deal with care of children matters. And so it's a very significant part of the Family Court business. Clause 4 of the bill creates new sections 4 and 5 of the Care of Children Act. And the question is that arises is how meaningful, in the light of the later provisions of the Act, the Family Dispute Resolution provisions, which we'll come to in Part 3, how meaningful those particular changes are, because those changes talk about appointing the lawyer to represent children. They talk about, the new proposed new Section 4 talks about promoting the paramount welfare and best interests of the child in the proceedings. And all the way through the new proposed Section 4, and that Clause 4, it is the constant reference to the welfare and best interests of the child in any proceedings before the court. But of course the reality is that going through the family dispute resolution process is, unless it's accompanied by an application that alleges violence in the relationship, is not a proceeding for the purposes of the bill. And so there's a real question about just exactly who it is who is going to be promoting the welfare and best interests of the child, because it's not going to be any officer of the court, and it's not going to be lawyers and counsel. And the reference, particularly in subsection 2 of the new section, proposed new Section 4, which says that any person considering the welfare and best interests of the child has to take a number of steps. Well, that has got to be the parents who are separating and who are bound up in their emotional turmoil, and any facilitator involved. And so I just think that there is now an air of unreality that part of the bill will now begin to represent. The new proposed Section 5 in Clause 4 of the bill sets out a series of principles relating to child's welfare and best interest, but it is really problematic to know exactly who is going to be taking responsibility for that. There is a new Section 7 to the Act under this clause relating to lawyer for the child, and that is a very significant change, because it goes from the present wording, which says that unless the court is satisfied that the appointment would serve no useful purpose, the court must make an appointment or a direction under the previous subsection to appoint a lawyer for the child, and particularly where there is an issue about the day-to-day care of the child. That wording, which is heavily emphasises or a presumption in favour of appointing a lawyer for the child, now becomes that the judge must be satisfied that appointing a child is going to be worthwhile, or is going to be, or relates to any concerns for the safety or well-being of the child, or the judge otherwise considers necessary, with no guidance as to how that discretion might otherwise be exercised. So, sir, this is a significant change. And this goes back to the point that has been made previously in debates in this House on this bill, and that is that this very much raises the issue of whether this bill will allow New Zealand to comply with its obligations under the UN Convention on the Rights of the Child, where children are, under that convention, guaranteed the right to be heard in matters that affect them, and where they are of sufficient age to instruct counsel to ensure that their views and their voice can be heard. So, Mr Chairman, that remains a very serious issue. And the Minister and the Chair might simply want to answer the question, how does the government expect to meet its obligations under that convention, given the provisions of this bill that will change the presumption in favour of appointment of a lawyer for the child to a presumption against that, and leaving the parents in their very emotional state to be the ones who together somehow, notwithstanding their differences, are meant to be determining the best interests of the child. That's an impossibility. that is simply just not a realistic prospect. And so we have very real concerns about the extent to which there will be compliance with those convention requirements. Then there is the issue about lawyers for parties under the new Section 7A in that Clause 4, and that fundamentally changes the role of lawyers. There's no question, and I think the Minister has basically admitted, is that she wants to see a much lesser... Mr Chairman?
Honourable Judith Collins.
Mr Chair, thank you for the call. I'd like to first off acknowledge the work of the Select Committee in this matter. It's been a very good